So moving on with page two. So page one was about page one and the whole inspection contingency, the language for the addendum KW. We're going to move on then to the rest of page two on the addendum KW, and it talks about closing location. So here it says the location is to be closed at Keller Williams, a clear title of Madison LLC, or a place designated by the buyer. So that's if I'm writing the offer for the buyer, the market of the moment, I probably wouldn't check that because in some cases that create an might create a counter offer. We don't want to create counters yet. We get more back to a balanced market. We like to close the deals in our own offices. So that's why you might choose that. Home warranty, this would be if the buyer is asking for a home warranty or if the seller is offering one, you've got to reference it in the offer so you're certain that the buyer gets it. So that's a clear distinction. Sometimes we'll say, well, it was on the MLS data sheet. I assumed it was just part of the deal. Unless it's referred to in the offer, it's not. So it says home warranty, and so I'm going to check that. Let's say they were offering a home warranty. It says seller agrees to provide buyer with a limited term home warranty agreement from our default is HSA, which is one of our great partners. Or and let's say that they've got another home warranty that they're already got in place. I would name that, and I would say effective is the time of closing and the cost won't exceed blank. That's where you're going to have to ask if they are offering one, the listing agent, what version of that they're offering, and then you're going to put that in. So let's say it's $495. And it is to be paid by, and this the default is by the seller. So again, if I want to make certain of that, I want to just strike through buyer. And again, default to seller anyway. At the time of closing, the warranty plan shall be provided by the listing of the cooperating broker. Again, if it's already in place on the listing, it's the listing broker. So I'm going to just strike the cooperating broker, and we're good. So that's it. Buyer brokerage fees. Now, this paragraph you don't need to use if it's an MLS listed property and it's showing an offer of compensation for a buyer's agent or a sub agent of some number that's acceptable to your client or to you. So I just want to tell you, sometimes people do this every time, and there's some inherent issues if you do that. Now, let's say that you're a buyer's agent and you're writing an offer outside of the MLS, so it's in a different MLS. There's no offer of compensation there, so then I would include that, and I would just fill it in. It says seller agrees to pay 3% of the purchase price or blank dollars, and I'm just going to put not applicable in there, to the buyer's broker at the time of closing to be applied towards the buyer's brokerage fee. Buyer has directed buyer's broker to reject the MLS offer of compensation, and it is understood the buyer's broker shall reject such compensation. So again, more times than not, you don't have to use this. If you're working as a buyer's agent and you're going outside the MLS, that's when I'd want to use it. Now, one side note, it does not protect you from a procuring cause conversation. So if if the buyer had already looked at the home with somebody else and then reached out to you to come in and write the offer, putting this in is simply not going to go away with the procuring cause issue, and that's a whole different conversation. So just know that. Now, if you're writing an offer on for sale by owner and you've got a buyer agency agreement, this paragraph on line 61 and 62 is great, and that is saying that the seller will pay X to you on behalf of you as a buyer's broker in the deal. Now, what that means is that if you have a buyer's agency agreement, you don't have to get anything signed by the seller in order to put that deal together, meaning you don't have to do a one party listing for the seller, none of that. Now, if I don't have a buyer agency agreement with the buyer, I don't have a contract with anybody, I do need an agreement with somebody. And so in that example, you might get a one-party listing agreement with the seller, or you may get a buyer agency agreement signed specific to this one property if you choose. And again, that's all you would need to do. So that's what that one's for. Now, licensee interest. This is interesting because by state statute, it says that you can't be a principal in a transaction, meaning you can't be the buyer and get paid a commission. So you can be a buyer in a transaction, you just can't get paid a commission. Now, you could get paid an incentive. And so this is just a workaround in state statute and languaging, quite frankly. And it says that if, let's say I'm going to be the buyer for the property, I'm going to include that. It says I have a valid license in Wisconsin and may realize a profit from any subsequent sales. That's disclosing to the seller that I'm buying and I may find a profit in it. It goes on to say any compensation derived from this transaction by the buyer through Keller Williams Realty, including any compensation references on line 57 through 62, so right above here, shall be considered an incentive to purchase and not a commission. So that's all that takes care of. That allows us to get what was being offered in a commission as an incentive to you as the principal in the transaction. Next paragraph talks about if we're asking for a buyer, a seller to do credits for the buyer. Again, in the market of the moment, that's typically not done. Yet, as markets balance back out, sometimes we can do that and negotiate that closing costs, financing, other prepaid items could be an incentive paid by the seller to the buyer at the time of closing. So that's for their use. And so that's what that one's there for. Now, subdivision regulations and building use restrictions. So, if the buyer is very specific about the property, that they want to know exactly what they can and can't do on the property, and if there's any restrictions for what they can and can't build, I would include this. And so it says that this offer is contingent upon the buyer approving the subdivision regulations and/or covenants, the building and use restrictions affecting the property. Seller shall submit copies of these documents to the buyer within blank days of acceptance of the offer. Now, that's when I would put not many days. I'd probably do 5. If buyer does not object in writing within, and I probably do 5 days within days of receipt of this, that the contingency shall be deemed waived. So again, what it's saying is that if there's a homeowners association subdivision regulations, the buyer's very adamant they want to know all of that before they close on the property. I would use this and then keep the timelines a little tight so that people don't get down the road investing money in things like the home inspection, the appraiser, all of that before they've had a chance to look at this. And so that's what that one's for. Now, if we know there's homeowners association dues, um, I would include that. It says that it's seller shall within blank days of acceptance provide the buyer with the amount of any. Now, here's the key: mandatory homeowner association fees, including any past due amounts. Some associations do have mandatory fees. Some are voluntary. So again, I'd probably learn that if I reviewed the subdivision regulations or the HOA documents, and then that's what this would come into play. Now, if I've got a property that's has a shared driveway or a joint well, then I would use lines 80 through 91. Again, this gives you the opportunity to get clarity with regard to that, and it gives the buyer the option to back out if what they receive isn't something that they are comfortable with as far as moving forward with the purchase. We did add a paragraph about attorney approval to make the offer contingent upon the buyer's attorney approving the offer. If they don't object in writing within blank days of acceptance, this will be deemed satisfied. Then it goes on to talk about what rights the buyer's attorney does have on behalf of the buyer with regard to the offer and the attorney approval. Again, I'm not. We would never tell a buyer or a seller not to run anything past their attorney. We'd never tell them that. In practice, we don't have attorneys involved in transactions very often. So, not telling you that this won't happen. I'm just saying that if a buyer ever asks you about it, I'd always say it's a great idea, and if you're comfortable with that, we can add in a contingency for your attorney to approve this contract, and then you grab the addendum KW and do that. Removal of the bump clause. I want to talk a little bit about this because this is interesting. So remember back in the WB11, if the buyer had a home to sell and they wanted to make their offer contingent upon that sale, then it created that bump clause, and we talked about that in the WB11 video. So this language though helps us with this on behalf of the buyer. It says, in the event that the buyer, prior to receiving notice from the seller that the seller has accepted a bona fide secondary offer, if the buyer delivers to the seller a written notice of an accepted offer on the buyer's property, seller's rights to declare the offer null and void pursuant to the closing shall be canceled. So what this is saying is, if we get our offer accepted and we have a bump clause, meaning it was subject to sale, the buyer puts their home on the market and gets an offer really quickly, and it's a solid offer, and the buyer says, I really want to remove any of that unknown that I might get bumped out of this offer I've got accepted on the house I'm buying. This clause is really good because then you draft a notice, you get it over to the seller or the seller's agent, and if that notice was received to them before they accepted secondary offer and served notice, then that whole thing is removed from the accepted offer. Now, It goes on to say if the buyer's property does not successfully close on or before the closing date set forth in the offer, the buyer may, at buyer's option, declare the offer null and void by giving the seller written notice that the buyer's property did not successfully close and all earnest money be returned to the buyer. See, this is where I like this one if I'm representing a buyer because it really puts some big protections in for them. So that's page 2 and 3. We're going to pick up the rest of the form in the next video, and we'll finish it out there.